companies.
So if somebody wants to buy a practice or a business, they would hire an economist like you to try to figure out what that company's worth. Is that right?
Correct. They'd hire a business broker, economist, CPA, whoever would be knowledgeable of that company. Right.
Are you a member of any societies or areas of economics?
Yes, sir. The main ones, I belong to a dozen probably, but there's nothing special about it. So you pay your dues every year, and sometimes they provide a platform for you to do a paper. But the National Association of Business Economists, National Association of Forensic Economists, American AEEFE, which is American Economic and Financial Association, and many, many others.
Okay. I want to talk about this thing.
Yes, sir.
Tell me what information you had to review to determine the net worth.
Sure. I had a spreadsheet that tracked Alex Jones' funds and information and money that trickled in from September 15, 2015 until December 31st, 2018. I know that's been discussed. That number was $165 million.
Okay.
It averages to about $53.2 million a year. But that is the starting point, because we know from testimony that Alex Jones said that he can do 70 million. And to extrapolate the 53 to today's date is about a 7.1 increase per year. It's a nice, healthy increase. But if you look back at 2018, there was also a draw that Alex Jones provided to himself. It was
What is a draw?
A draw is a salary and a payment in advance of work that could be done, or it could be just a flat payment.
Just taking money out of the company, in other words.
Correct. And we know that from the testimony of Brittany Pays that it was $18 million over a 3-year period. So if you dissect that and you say it's roughly $6 million a year, and you add that to the 53 million, then you're close to 70 million. So we know that that's the foundation, the starting point for determining the value of FSS or InfoWars.
Did you do some independent research also?
I did, yes, sir.
What did you do?
I tried my best to look at the way we could position Alex Jones companies that would fit a standard industrial classification code. There are 600 codes, but when you drill down and try to figure out where does Alex Jones fit in this, with all the things he sells and all the ways he makes money, it's not possible. We could call him a health food store because he does vitamins and nutraceuticals and makes money on a lot of products. But we can't really put a finger on what he does for what he actually makes his money doing. I want to mention one more thing. I believe that Alex Jones was a revolutionary. I think he was a maverick. He was like Genghis Khan. He went into the internet when nobody was there. He was 17 years old when he sat down and had a talk with his dad, with this old man. And I can imagine that talk. His dad's a successful dentist, and he wants to become a radio star like anyway. But that must have been a tough talk. So his dad helped him. In fact, his dad took out the first ad on his radio show. So his dad was 100% behind him. And believe me, Alex Jones is as much of a maverick as he is much of a outsider that he is. He is a very successful man. He promulgated some hate speech and some misinformation, but he made a lot of money and he monetized that. My thinking about him was he didn't ride a wave. He created the wave, and he has now 3.5 million clicks. He has 100 radio stations. He is a very successful guy.
Billion clicks, right?
Correct. No question about it.
I want to talk to you about some of the companies he has. More than just free speech systems, right?
Right.
You want to know.
I was about to reach for the date when he incorporated, but I know what it was. I know the date.
Do you know the other businesses that Alex Jones owns?
I do, but Your Honor, I wrote them down in a little spreadsheet and with the dates that they went to the SOS, the Secretary of State, and chiseled those corporations as LLCs in stone. May I look at that sheet?
Yes, so these are notes you took in preparing your report.
Correct.
Yeah, that's fine. Don't read from that.
No. I'm just going to try to find. We know about InfoWars. We know about free speech systems. He also set up many other companies that benefited him internally. But those are the two main companies, and those are the numbers we have been discussing so far today. But the other companies include, and I'll find them in a minute.
I know, I'm sorry there isn't a surface at the witness
That's
stand.
okay.
You're not the first witness to wish there were.
That's fine. Okay, I'll okay. You're on. Okay, let's just start with the main one, Jones Productions, Jones Report LLC, InfoWars LLC, Prison Planet. I'm going too fast. I'm sorry. Prison Planet TV LLC, Planet InfoWars LLC, InfoWars Health. These are the products it sells. PLJR Holdings, and we'll discuss that, I'm sure, in a minute. And AEJ Austin Holdings LLC. And also, I'm sorry.
PQPR,
No, PR.
PQPR.
Sorry.
Are you familiar with PQPR?
Yes, I was just gonna talk about that.
Okay.
PQPR is one of the holding companies that works in conjunction with Free Speech Systems and InfoWars to sell products, to host these shows, to do a lot of the front work that Alex Jones makes his profits from.
Are you familiar with the term shell company?
Shell company?
Yes, sir.
Sure. Yes, sir.
What's a shell company?
The shell company is a U.S. corporation that sets up shop in one of the islands, or in Switzerland, or in some offshore location to prevent taxation on that profit. They also set up shop like Microsoft has done to build products. The way the shell company would apply in this case is an internal set of affiliates that Alex Jones set up, two of which include his parents. And keep in mind, the main reason, in my opinion, why the numbers don't add up, because we didn't have balance sheets, we didn't have income statements for years, we didn't have cash flow statements, we didn't have bank records. So it's almost like trying to piece this together.
Mr. Pennigo, you understand all that stuff was ordered by the court to be produced, right?
You're right. Yeah, I do understand. Of course. And you know how many times I've asked you for it over the last few weeks, Council, and none of that was produced.
Right. I'm sorry, Noel, you were talking about shell companies.
Sure. And in this sense, it was to take the affiliate companies and monetize those, benefit by those. In fact, there were two notes that were signed in 20.
I'll subject to this line of questioning is irrelevant. It's supposed to be here on net worth, not on.
Overall,
There were two loans set up, two things that were set up to benefit that we're talking about, the shell companies. These were to benefit Alex Jones for years and years to come. He set up these two loans, so to speak. One was for $29.5 million, the other was for $20.5 million. The total had to be $53 million, one over a 30-year period and one over a 15-year period, with very low interest on payback. And that simply means that Alex Jones was obligated to make a payment on the interest annually and to pay back the first loan, which was a 30-year loan, intermittently over time, which he had started to pay. FSS started to pay that loan back at the rate of $11,000 a day, but they didn't keep this up. This started back in 2021, but they didn't continue to pay that. So as a result, on the books, Alex Jones is carrying this note, this gigantic note, $53 million note, when in reality, he's using that note as a clawback to pay himself back. And very simply stated, it's a convenient way of doing business. Before 2018, his business was a non-business. His organization charters are inverted T, which means everything flows to Alex Jones. And I agree with that. I think Alex Jones made all the major decisions. And I think Alex Jones knows where the money is. He knows where that money went, and he knows that he's going to eventually benefit by that money. One of these notes matures when Alex Jones is 74 years old. He's only got a life expectancy to 76. And he is the remainder man on the first one, meaning he can take that money after the estate is settled and put it in his pocket. The other note matures in 15 years, and he's obligated to pay an interest rate every year of over $1.9 million, which apparently hasn't been paid. If it hasn't been paid, we don't need to reconcile.
Is the purpose of a note like this to make free speech systems look like it doesn't have the same kind of net worth as it does?
Absolutely, in my opinion, you know, when you carry to the bottom line a debt of $53 million, there's no above the line write-offs and line item expenses that even come close to that. Even if you add up all of his indirect ways of paying himself, salary and advances and administrative fees and consulting fee, all that is bundled into the cash flow and profit and loss. But when you look at a $53 million debt, that dissolves and disintegrates and wipes out anything above the line. So that's why he can say he's broke, he has no money. But we know that's not the fact.
PQPR, where's headquartered?
Sorry?
Let me ask you this, PQPR doesn't do actual business, right?
No, there's no employees, doesn't do any business, correct?
The other companies that you named, they don't do business either, correct?
Correct. Okay. Make that clear. We're really talking about FSS, InfoWars, and Alex Jones himself, AJ.
When you say FSS, that's free speech systems.
Correct.
I just want to make sure that you're.
Yeah, I'm sorry.
It's okay. You're talking about the notes that PQPR that Free Speech Systems pays to PQPR.
Correct.
They started paying $11,000 a day, correct? One point.
At one point, it was chiseled in stone that they would have to pay that, correct?
That started in September of 2021, right?
Correct.
What else happened in September of 2021 that's relevant?
In my opinion, the default judgment, same week, September 27th.
When the court ordered that Alex Jones did what we claimed he did, he started paying $11,000 a day from Free Speech Systems into his shell corporation, PQPR. Correct?
Exactly.
From the information that you do have, the limited information you do have, were you able to determine an annual revenue, how much money was coming into Free Speech Systems?
Yes, sir.
How much in 2021?
70 million. If we talk, oh, sorry, let me back up. In 2021, the net revenue from the FS,
You may look at his notes.
Yes.
just 1 second.
That's fine.
I'm sorry because
It's okay.
It's all right.
Okay, thank you.
I don't have a problem with notes. I just need to know what you're.
If the question was, in 2021, what were the, can you phrase the question again?
What was Free Speech Systems revenue? How much money did they take in 2021?
I'm sorry. $64,970,861.45.
You heard Alex Jones testify that his goal in 2012 was revenues of around 70 billion if he hit it.
Correct.
So that's, we're getting close to that number, right?
Exactly.
We have the revenue numbers for 2016, 17, and 18 just from the InfoWars store, correct?
Correct.
We put up exhibit 35 and go to the last page. That number is on the screen in front of you, Dr. Pettigrew. Is 165,230,14.62, correct?
Correct.
That doesn't include sales on like Amazon or eBay and things like that, right?
No. Amazon, eBay, other sources.
Just donations.
Donations, right, that was another, in last year, $8 million.
So my point is, in 2015, 16, or sorry, 16, 17, 18, his revenue is pretty consistent with what it was in 2021, right?
Correct, even though we don't have records.
You've
Past,
heard,
past 18.
you've heard Alex Jones say he was deplatformed in 2018, right?
Correct.
And that was some sort of financial punishment. He lost millions. You remember that
I
testimony?
remember him saying that, but the records don't reflect that.
Right. In fact, he actually is making more money after 2018, right?
Correct, and his deplatforming wasn't because of Sandy, it was because of other reasons, as you know.
Did you do research into that?
I did.
Why was he
Objection,
deplatformed?
Your Honor. This is not part of this.
overruled.
Located an article that discussed in great detail why he was deplatformed.
Why was
I object to the hearsay, Your Honor, from his article.
So,
From your research?
okay,
Let me ask the question.
all right, yeah, ask it.
From your research, Dr. Pettingill, in 2018, why was Alex Jones deplatformed?
He was deplatformed for the following reason.
Speak up just a little bit.
Sure. He was deplatformed for the following reason. Just read it into the record.
No, I'm sorry. I object, Your Honor, to him reading into the record from some of these articles.
It's the quotes from the actual people that deplatformed tell why he was deplatformed from the different social media sites.
Right. What is the hearsay exception that allows this? to happen?
He's an expert that can rely on it. He's not going to put it into evidence. He's just going to read it as under.
And did Mr. Pettingill, excuse me, sir, use this in developing his expert opinion today?
Well, he wanted us to get into the deplatformation and see if it actually lowered his revenue and if the deplatforming was related to Sandy Hook or something. So this is something he did research on and relied on, form his opinion that it's not related to Sandy.
But also, if I may, Your Honor, I remember looking at that rule when we had our last expert witness on it. Also, I think has to be a learned treatise commonly relied on by these.
Well, that exception does. I don't know if Mr. Farah is trying to point me to a different exception.
Texas Rule Civil Procedure 703, Your Honor.
Right. So he certainly can base his opinion on the information, but this is about reading it out loud in a quote to the jury. Is there an exception for that?
I do think it's under learned treatise. He says that what the.
Well, you have to go through where it came from. and
Right.
all of that.
Let's just do it this way, Dr. Pettingill. I'll withdraw the question.
Sure,
Without reading
Rephrase it.
without reading it from your research, why was he deplatformed?
sure. The deplatforming in particular from Facebook stemmed from hate speech, from language which was described people such as transgenders, Muslims, immigrants in a sort of a hateful way, it says here. And InfoWars has been accused of other, I won't even carry on and report that, but other remarks, let's leave it that way.
And inciting violence also?
Correct, yes.
If we look at the revenue number of, let's call it 65 million, 64.9 million, why is revenue important to determine the net value or net worth of the company?
Because if we're trying to sell a company, there are rules of thumb selling companies that are privately held. It's usually 1 to 2 times revenue. And that's a universally accepted algorithm for trying to value a company. In this case, we take the 65 million and we assume there's a multiple of 1, which would be the floor or the ceiling. I'm sorry, 65 million would be the floor. And we assume that the multiple of 2 for a 2-year times revenue earned would be 130 million. And that would be some range to put a number on InfoWars and free speech systems.
Now, in your expertise, would you lean more towards the 1 or the 2 times valuation?
You know, the government and professionals who value businesses. They rely on IRS income tax returns based on paid income taxes and asset values. We don't have that. We don't have. So I don't know if I should lean toward one that's the floor or two, or two toward the ceiling. It's probably somewhere in between.
He's been on the air for a long time, right?
Oh, yes, sir.
We know from at least 2016 through 2021, his revenue stayed relatively the same, correct?
Correct. 50 plus million a year. Correct.
I'm sorry?
50 plus million a year.
You know, he has a loyal following, correct?
He has a rabid following. Correct.
Would those factors help you lean closer to the 2 times revenue?
It would. And there are other reasons for that, because he has an ongoing concern. He has a very successful practice, very successful business, and he has these rabid followers. He, for the most part, is the key man of this organization. If he had to buy insurance on himself, I don't even know what value he would put on himself. It would be in billions probably. So I think for that reason, we can assume it's closer to 2.
Okay. And if it was 2, that would be $130 million would be the net worth of Free Speech Systems.
Correct. Minimum.
You say minimum because we don't know all the revenue streams.
We don't know Amazon, we don't know eBay, we don't know all the other sources, and any other ad revenue he gets, you know, with all those clicks, and I don't know this for a fact, but with all the clicks.
Witness just said he doesn't know this for a fact. I don't know why he testified to it.
He's saying what the revenue streams could be without saying a number. We don't have the number.
Calls for speculation.
Okay, I actually don't think I can address that until I know what he's going to say, so I think I have to hear it.
Right.
You're an expert, you're here testifying as an expert, that means you get to tell us opinions, which other witnesses don't get to do, but we also need to know what those opinions are based on, so just consider that as you're testifying.
With respect to the ad revenue, we don't know how much he makes from ads. Typically, someone makes money from ads because if they can click and direct someone to a website and purchase products, they get paid a commission on that. That's how many of these web guys make money. So we don't know the numbers, we don't have spreadsheets on that, but we know it's an unknown, and if you just do the math on the millions of clicks that he gets, then technically speaking, he's making money from that.
Let's turn to the net worth of Alex Jones.
Sure.
Tell me what you did. I'm sorry. Excuse me. Tell me what you did to try to determine the net worth of Alex Jones.
Sure. Alex Jones withdrew $61.9 billion in 2020. I don't know if that was a one-time withdrawal or it was accrued pay over many years. There's been discussion that it was over a 10-year payout. It doesn't matter. $61.9 million. And that number represents, in my opinion, a value of Alex Jones' net worth. He's got some money put in a bank account somewhere. He had 4 accounts we know of at Security Bank, but we don't know what's going into that account. We don't know how much money was apportioned to the account, and we don't know when the money was put into the account. But we know that there is a statement saying $61.9 million was withdrawn and paid to Alex Jones.
From Free Speech Systems
Correct.
in 2021.
Correct.
You're saying you're the default judgment for it.
Correct.
Do you have any records of other money being pulled out of Free Speech System and given to Alex Jones in this contract?
I do. From the testimony, the notes from the Brittany Pays, she mentioned that another 18 million was taken before this year, before this 61.9 million. It was 18 million over a 3-year period, 2015 to 2018, $18 million.
So that totals about $70 million.
If you add the 6 per year to the 53, you get 60 million, but close to 70. And as I said before, there's been testimony that is made this year on track, or I'm sorry, 2021, 70 million.
Okay. Does that help you determine the net worth of Alex Jones?
Yes, sir.
What did you come up with in that opinion?
Same approach to his net worth that I took to valuing the companies would be 1 to 2 times his net worth. And you can do the math on that.
So 70 to 140 million?
Correct.
140.
Correct. And those are very simple numbers. And there's no economics of their present value. Those numbers speak for themselves.
So if we look at the final number in the high end, that is about $270 million for the net worth of Alex Jones and Free Speech Systems.
Correct.
And the low end, the low rate to that, if it was just one, would be 135 million.
Correct.
Are all your opinions given today to a reasonable degree of economic probability?
Yes, sir. Correct.
I don't have any more questions. I appreciate it.
All right, thank you, Mr. Reno.
The doctor?
You can call me anything you like.
I won't take you up on that. But Dr. Pettingill, we've never met before.
No, sir.
I never took your depositions.
No, sir.
You've never given me an expert report.
No, sir.
This is our first chance to do this.
I saw you in the elevator twice.
I guess we will. So let me ask you, have you been paid to testify here today?
Not yet.
Okay. Have you made an agreement with plaintiff's counsel to get paid?
Of course.
How much are you going to be paid? Is it hourly?
It is hourly,
What's your hourly rate?
$4.50.
And how many hours have you devoted approximately to preparing to testify?
Approximately 20 hours.
And then you're going to get paid for the time you spend on this.
I get paid from portal to portal.
And you've spent some time with the plaintiff's attorneys?
I did. A couple of hours just.
And that was preparing to testify.
I was going over the records for the most part.
And did they give you some idea of what questions they wanted to ask you?
No,
Did they give you some direction as to what you were supposed to do in this?
of course, I had a charge to tell the jury, but no real specific or particular questions.
Do you know what it costs to produce a media show?
No,
You would agree that that's what Alex Jones does, and that's what Free Speech Systems does, wouldn't you?
right, but that's a loaded question. You said what it costs to produce a show. You know, there's so many tangibles involved in that question. It involves television equipment, it involves personnel, it involves writers and directors and producers. So that's a loaded question. I can never answer that. I don't know if Alex Jones could answer that.
Well, have you reviewed public records in preparing to testify here today?
I sure am.
And there are some federal court records that you reviewed?
Not federal courts, no. I relied on primary research as it was available to me on the internet from state of Nevada and from other locations.
So if there were sworn statements in federal court attesting to the financial wherewithal of Free Speech Systems, you didn't review them?
Federal court, absolutely not. Unless you can refer me to some document that I was asked to review.
Well, I've sent you some documents, haven't I?
Yeah,
And those are from federal court, aren't they?
I don't know that. They're not base stamped. I don't know where they're from.
Well, the document I sent you has the name of the court on the top of it, doesn't it?
Sure, but unless it's base stamped, to me, could be a preliminary document, could be something that you submitted that was sent back to you. I don't know.
You've testified before, right? In other cases? Many other cases? 1,500 other cases. Okay, so you're aware that courts have something called docket numbers, right?
Sure,
And when you and courts have websites, right?
sure.
And you can go to the website and put in the docket number and then see what's been filed in court, can't you?
Where's this question going? Are you trying to circumvent and trying to get back to your original question about why didn't I look up what a radio station costs to finance? Is that
I'm
the question?
asking you, my question to you, sir, is the documents I sent to you have at the top the case number and the name of the court. Did you go in to the court's website and look up the case to see that those documents were actually filed?
No.
And those documents that I provided to you are sworn under oath, aren't they?
I believe so.
Let me move on.
Sure.
Let's assume a sale of MSS,
I say all right.
a sale of Free Speech Systems LLC.
Okay.
Does Alex Jones have to work there?
Absolutely not. But it would be to the owner's advantage to keep him on for a few years to benefit by his key man status and his connections and his following. It's senseless not to keep him on.
And the reason it would be senseless to not keep him on is because without Alex Jones, free speech systems is basically worth nothing.
I can't say that for a fact, because keep in mind, there are lots of products that are sold, millions of dollars of products. And Alex Jones has got a long-term reputation of selling these products and promoting these products online and leading people to websites to purchase it. So it may take FSS free speech systems on sale may take a hit to the downside initially, but because of the pipeline of products, it probably could continue to make money.
Nobody buys products because free speech systems is selling them. They buy them because Alex Jones is selling. Isn't that true, sir?
They buy them because Alex Jones puts forth a statement attached to those products that generates, in most instances, some type of fear. You know, fear news travels 6 times faster than regular news. We heard that from one of the experts. So with that in mind, people do buy products endorsed by Alex Jones for a certain reason, and he makes a lot of money doing it. And
Let's
so does
get back to
FSS.
my original question. If we were to sell FSS and Alex Jones didn't work any longer, FSS would basically be worthless other than its television production.
Is that a question or a statement?
Do you agree with that statement, sir?
I think over time it would become tenuary. You know, we would go into the red, but not initially, because there's always some kind of a stream carry forward with the effect of Alex Jones. Believe me, he's been doing this for years.
Well, let's say he went and you started doing it at another company at the same time. What would FSS be worth? He moves over onto ESS and starts selling his products on ESS rather than FSS. What's FSS worth?
It would take it.
It would be worth pretty much nothing.
No, I can't say that. Ongoing concerns don't go to nothing overnight.
It would go to nothing pretty quick.
Define it. Please.
PQPR has employees, doesn't it?
It does not.
It does.
Yeah.
And PQPR has a huge warehouse, doesn't it?
It has a warehouse, and it does pay security. It does pay rent. They don't own the warehouse. They don't own the building. They pay to themselves.
And it has a massive inventory of products, does it not?
Yes, sir.
And it purchases approximately $500,000 worth of products per month, doesn't it?
It does, and sales have been very slow. I may add, in 2021, $120 million was on the books for product to be sold. When you look at the accounts receivable, it was $110,000, which means it's not much effort to sell those products. They're sitting somewhere. But that doesn't mean they're worthless. You can sell them at a fire sale and still make some of your money back, lots of your money back.
You started off your testimony by saying that PQPR was a shell. PQPR is a real company, isn't it?
It's a real company. That's right. But
Now,
it's an affiliate company, which makes it a quasi-shell company. All of Alex Jones' companies are affiliate companies.
you made an effort to testify about money for clicks.
Money for what?
For clicks. You said he
Yes.
must make money for clicks.
Correct.
Have you spent much time on his website?
No.
So you can't tell us, as you sit here today, whether every product that is actually advertised on his website is a product that he sells.
Correct. No, that's not true. He does sell other folks' products, no question about
And you've done that based on personal research?
it. No. From just, I would say, discussions with one or more of his fans.
In terms of valuing Alex Jones has a special talent. Would you agree with that?
No question.
And in that way, he's kind of like a baseball pitcher who's got a good arm.
I think a better comparison would be more like a neuroscience surgeon, neurosurgeon. He's a specialist.
Okay. And as a specialist, in order to value a person with a special talent, you need to have a contract to produce, don't you? Just like the pitcher with the good arm, his arm can go tomorrow, can't it? Or the neuroscientist can suffer a head injury, fall off his bicycle, right?
Sure.
And so in order to value somebody going forward, they would need to actually have a contract that would require them to be paid, wouldn't they?
And would require the seller to provide services for a limited amount.
And neither of those are true.
No.
No further questions.
All right, Mr. Farah?
If somebody was gonna buy free speech systems for $270 million, part of that transaction would be Alex Jones has to continue working there for some number of years, right?
I'm sure there's always a transition to train and make compliance.
And that's common. When people buy some sort of company, that the founders have to continue working. That's part of the purchase price, right?
Of course.
So if Alex Jones got $270 million for free speech systems, he would, part of that contract would be he'd have to continue working there for some amount of transition time, right?
No question.
That's part of the evaluation that you did, right?
No question.
And there's other hosts, like Owen Schroyer hosts, right?
Yes.
There's other hosts that get on and host shows. Robert Barnes, for instance.
Sure.
Okay.
None nearly as successful as Alex Jones. I might add.
The point is, in your evaluation of free speech systems, you took into account the fact that for that kind of purchase price or net worth, that he would continue. That's how you evaluate businesses like that.
Yes,
right?
correct. Absolutely correct.
No more questions. Appreciate it.
We're asking about how you evaluate businesses and the net worth analysis just now. Do you include unliquidated liabilities like other pending lawsuits?
That's a great question. But let me answer this one. When
You have to answer my question.
I'll try to answer it in a roundabout way. When we're asked to evaluate a company, a trading company that sells stock, invariably the 10K, which is the annual statement, or the 10Q, which is a quarterly statement, will have footnotes, and it will say categorically, allowance for doubtful accounts. This could occur, and they'll put a big chunk of money aside in case that happens. It happened in Monsanto. Monsanto had huge footnotes saying, we know we caused some damage to farmers worldwide, and we are going to put aside X billions of dollars just in case we get sued. It didn't happen in this case because we don't have any balance sheets, income statements, 10Qs, or 10Ks.
And because their FSS has absolutely no obligation to file those kinds of documents.
Absolutely.
It's a privately held.
Correct.
Now, did you consider in arriving at this net worth calculation, other unliquidated debts from lawsuits where Alex Jones has already been found guilty?
Object scope.
Object to scope.
It's outside the scope of my
Oh, I
redirect.
think that's true.
He was, may I respond to him?
You may.
He was asking questions about what went into his calculation of net worth during the scope of his redirect. And I'm exploring that same issue.
I was worried about it.
That's not how it works. All right, hang on. Okay,
No further questions.
all right. For my jury, remember all of my prior instructions. You are not allowed to have any conversation with each other while you, at all, until I tell you what you can about anything that's happened in the courtroom. You do have an opportunity, just an opportunity, not a requirement, to address any questions you may have, each of you individually, this witness, and you may head back into that now. Thank you.
All rise.
Shut the door behind us. Thank you. Everyone may be seated. Mr. Pentel, you'll have to wait in the hall when we come back with questions. You can leave your stuff up there. No one will touch it. I've just asked Ms. Ford to bring out the charge for us, so we'll just wait and see if she can bring it out. You may, you don't necessarily have to, you will have to. Okay, so she's printing it.
Would Your Honor want us arguing this morning?
I would say so. Oh, it's 9 o'clock.
No, I agree. So Mr. Pettingill and then get right into it?
That's my understanding. That we don't have another witness. Right?
That's correct.
So arguments. Okay. Oh, you have no copy. Yes. Oh, no, I want them to have a, well, it didn't, but I want them to have a look at it. All right, we've been working on it, as we go through. So let me see if she made that change.
One thing I wanted to bring to Your Honor's attention
All right,
is that we are going to have an objection to 3 questions being submitted. We believe they need to make an election to prevent a double recovery from Mr. Hess.
they can make that election post. That's possible. Yes, so. That's not how it's worth it.
I do not.
I have this ready for you. It just doesn't make any sense. Yeah. We need to change the self. So here, we can do it this way. Here you go. So I gave you some stars and then there. All right, we don't quite have it ready. I'll bring it out when I come back.
All rise.
Oh, yeah. That's
Hey, let me send you one more.
Never stopped.
Just do it. Which one? Yours. That's what I'll do too.
Something my credit card. Can you please disregard?
right, you may be seated. First, one person from each table will come up here. I have version 1 of charge 2. Now we'll go over the questions. Oh, I actually brought an extra. Do you want an extra, Mr. Karen? You have so many people. Yeah. All right. Ready? Off the record. Mr. Pettingill is outside?
Yeah, John.
Okay. How common is it that executive types pay themselves via loans from the corporation? That seems fine. In determining that Alex Jones is a special talent, did you ever watch a complete broadcast by him? I don't know. Did you consider both current and future lawsuits in coming to your calculations of free speech systems value? What is the going rate per 1,000 impressions of a banner ad? Did you look at any financials immediately before and after the quote deplatforming to determine if revenues did or did not suffer? You mentioned a net worth of between 135 and 270 million. Is that for Alex Jones as an individual or for his companies? Which companies? From a financial perspective, can you further explain the difference between the net worth of an individual and the net worth, and the worth of a company that individual owns? In the sale of a private company, would the founder typically agree to a covenant to not compete? And if so, could you explain how that works? Could Alex Jones maintain the value of free speech systems through relatively infrequent appearances on InfoWars, essentially licensing his image? Can you please explain with examples what a liquidated asset is? In your experience with any other company's finances, if there was a company that was being sued for punitive damages, what is the typical ratio for punishment versus company value? If free speech systems sold, how would the loans to Alex Jones be accounted for? All right. I don't think it's relevant whether he watched any episodes. How common is it for executives to pay themselves with loans? I think that's okay. I don't know that it matters, but that's okay. You gotta shut the door, please. Did you consider both current and future lawsuits in coming to your calculations of FSS's value? Do you have an objection?
I do, Your Honor. I think it's bringing in a collateral matter.
Yeah, I don't think I agree. What is the going rate per 1,000 impressions of a banner ad? Okay, he knows. Did you look at any financials immediately before and after deplatforming to determine if revenues did or did not suffer? Sure. Net worth, is that for Jones individual or his companies? That seems fine. Difference between the net worth of an individual and the worth of a company the individual owns. The covenant to not compete question. You guys interrupt if you have an issue.
I think the covenant to not compete question, well, I don't see that he has relevant expertise in that area.
I don't know if he does or not.
Yeah, I'll agree.
Okay. Could he maintain the value of FSS through relatively infrequent appearances, essentially licensing his image? I think that's fine. What is a liquidated asset? If you're in your experience with any other company's finances, if there was a company that was being sued for punitive damages, I don't know why I'm saying it wrong. There we go. Punitive damages. What is the typical ratio for punishment versus company value?
We'd object.
Yeah, I don't think he gets to answer that question. If free speech systems sold, how would the loans to Alex Jones be accounted for? Okay, I think those are all good. So everyone agree? All right, on the record, we've gone through the questions submitted by the jury, eliminated a few, kept a few. Any objections to the remaining questions, Mr. Rivera,
Okay.
Mr. Randall?
Okay.
All right, let's bring back our witness and then our jury. I'd love to do a charge conference, like, I guess, do you need time? Are you gonna need a break? No break at all? Okay. Take a look and let me know so we can do it. Maybe if there's no, we just do it with the jury in the room even.
All rise.
You may be seated. So I have a few questions to ask you. Just listen to the question, answer the question you're asked. This is for the jury and to my jury. If you don't hear your question again, that's because I made that decision. Are you ready, sir?
Yes, sir.
How common is it that executive types pay themselves via loans from the corporation?
Very common. We would pay forward to assure that a key employee is going to remain employed, so it's standard fare. And it obligates the employee to remain on the books and remain faithful. And normally there's a penalty. Those loans all carry interest rates. But in this case, the two loans were interest rates 1.8 for the 15-year and 1.75 for the other way around, 1.8 for the 30-year, 1.75 for the 15-year loan. So it's pretty standard. It's taxable too. Money eventually will be taxable.
What is the going rate per 1,000 impressions of a banner ad?
But see one.
What is the going rate per 1,000 impressions of a banner ad?
I'm looking at you like it's incredulous. I have no idea.
That's fine, tell them, you have no idea.
I have
You
no
don't
idea.
have to know.
I'm sorry, I don't have any idea. If you ask me any advertising questions like that, I'm sorry, I'm in short circuit and say I don't know. I have no idea.
Okay. Did you look at any financials immediately before and after the quote deplatforming to determine if revenues did or did not suffer?
Excellent question, whoever posed that. Revenues did not suffer. And Alex Jones stated the reason it didn't suffer was because of COVID. He said it was COVID related. And deplatforming, as I mentioned earlier, was not directly tied to Senator. He had other reasons, but he did not suffer any losses. He didn't take any hiccups. He made as much money after that as he made before, but we don't have records. We just know from his summary statements that he didn't suffer any hits to the downside.
You mentioned a net worth of between 135 and 270 million dollars. Is that for Alex Jones as an individual or for his companies? Which companies?
Well, it would be the companies that generate income, PQPR, FSS, InfoWars. But you cannot, as I mentioned, trying to mention earlier, you cannot separate Alex Jones from the companies. He is the company. I mean, you really can't say this company made so much money. Bottom line is Alex Jones generated that much money. He monetized his stick, his methodology. He was first to the game, and he will never not have a job. He's like the guy. And catch me if you can. He can go to Tulane or Loyola, any of my universities, and teach a course on how to do it. He was the first guy to do it. He broke ground on it. He was very successful, and I commend him for it.
From a financial perspective, can you further explain the difference between the net worth of an individual and the net worth of a company that individual owns?
No, there's really no difference. I mean, you could look at what he drew out of the business for his own net worth. And we talked about that, almost $62 million, and he took that out and went into a bank account somewhere. But there's really, in this instance, there's no difference. He is a company. He's the guy. You want to put a label on it and say half of it is for his company, half of it is for him personally, that's fine with me. It's all the same, that's your money.
Could Alex Jones maintain the value of free speech systems through relatively infrequent appearances on InfoWars, essentially licensing his image?
Listen to this trial for a week, Your Honor. Those questions are phenomenal. I don't know. I don't know the answer. I don't want to guess. I'm here to give you facts, and I don't want to guess. But that's a great question. I think he's the only one that can answer that.
Can you please explain what a liquidated asset is?
Sure, it's something that's either sale at force base. A liquidated asset sells for two reasons. One, it's liquidated in the sense that someone needs the money, and it can be sold at a fire sale at a very low discounted amount, or it can be just liquidated in the open market. It really doesn't matter. But in the case of selling a company that's in trouble, then it would be considered a fire sale to liquidate the assets, and the assets are huge. And there are other assets which haven't even been discussed. I mean, there's a hidden asset somewhere down the line. On Brittany Pay's deposition, I think it's on page 114, she mentions that she
Objection on this one.
Sustained. So just the question was, can you explain what a liquidated asset is?
I'm sorry.
That's okay. If free speech systems sold, how would the loans to Alex Jones be accounted for?
They'd have to be paid back. They'd have to be embedded in the sale price with the interest factor built in.
All right. Thank you so much, Mr. Penfield, for your time and your testimony. You are now free to exit the witness stand and resume your day.
Thank you.
Thank you so much. Can we do this right here, or do we need to have a conversation without the jury?
You're right. Marcy.
So no objections. Okay, so you have been given a charge of court of both sides. Any objections, Mr. Fair? Mr. Reynolds? All right. Ladies and gentlemen of the jury, at this time, I'm now going to present to you the charge of the court. Copies of the charge will be made for each of you. I don't know if they're ready, but you'll have them later. If they're ready while I'm talking, I'll let Ms. Massey still bring them out so you can read along, but they'll be available for you in the back. During arguments of counsel, do not read or refer to it unless specifically requested to do so by counsel. It may be read to you again later by the presiding juror, and you may refer to it during your deliberations. So this is not the only time you will hear it. After I read the charge, under the rules, the attorneys are permitted to present to the jury their summations of the evidence in light of this charge. And just to be clear, that means all of the evidence you've heard in this trial, not just today's evidence. It's all part of the evidence. The attorney for the plaintiff is permitted to proceed first, then the attorney for the defendant, and then the attorney for the plaintiff is permitted to close. I'm going to read the charge of the court now. Members of the jury, after the closing arguments, you will go to the jury room to decide the case, answer the questions that are attached, and reach a verdict. You may discuss the case with other jurors only when you are all together in the jury room. Remember my previous instructions. Do not discuss the case with anyone else, either in person or by any other means. Do not do any independent investigation about the case or conduct any research. Do not look up any words in dictionaries or on the internet. Do not post information about the case on the internet. Do not share any special knowledge or experiences with the other jurors. Do not use your phone or any other electronic device during your deliberations for any reason. In the case of an emergency, others may contact you through my judicial executive assistant at the number previously provided. Any notes you have taken are for your own personal use. You may take your notes back into the jury room and consult them during deliberations, but do not show or read your notes to your fellow jurors during your deliberations. Your notes are not evidence. Each of you should rely on your independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken notes. You must leave your notes with the judicial executive assistant when you leave the courthouse. We will make sure your notes are kept in a safe, secure location and not disclosed to anyone. After you complete your deliberations, we will collect your notes, and when you are released from jury duty, we will promptly destroy your notes so nobody can read what you wrote. Here are the instructions for answering the questions. 1, do not let bias, prejudice, or sympathy play any part in your decision. Everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes that we may not be aware of, but that can affect what we see and hear, how we remember what we see and hear, and how we make decisions. Because you are making important decisions as the jurors in this case, you must evaluate the evidence carefully, and you must not jump to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. Techniques to identify and check one's implicit biases include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions or making assumptions that have no basis in the evidence. Asking yourself whether you would view the evidence differently if the players were reversed or other types of people were involved. And listening carefully to the opinions of your fellow jurors, each of whom brings a different valid perspective to the table. Our system of justice is counting on you to render a just verdict based on the evidence, not on biases. 2, base your answers only on the evidence admitted in court and on the law that is in these instructions and questions. Do not consider or discuss any evidence that was not admitted in the courtroom. 3, you are to make up your own minds about the facts. You are the sole judges of the credibility of the witnesses and the weight to give their testimony. But on matters of law, you must follow my instructions. 4, if my instructions use a word in a way that is different from its ordinary meaning, use the meaning I give you, which will be a proper legal definition. 5, all the questions and answers are important. No one should say that any question or answer is not important. 6, answer yes or no to all questions unless you are told otherwise. A yes answer must be based on a preponderance of the evidence unless you are told otherwise. Whenever a question requires an answer other than yes or no, your answer must be based on a preponderance of the evidence unless you are told otherwise. The term preponderance of the evidence means the greater weight of credible evidence presented in this case. If you do not find that a preponderance of the evidence supports a yes answer, then answer no. Preponderance of the evidence is not measured by the number of witnesses or by the number of documents admitted in evidence. For a fact to be proved by a preponderance of the evidence, you must find that the fact is.
Sorry, I just was listening. I need to vote.
Fine. All right, you know what? We have a discussion that the lawyers and I need to make. I thought we had resolved everything, but that's not the case. So I'm gonna send you back to the jury room for a break. This is not an opportunity for deliberations or discussion. Remember all of my instructions.
All rise.
All right, well, I need some recording because I don't, oh, right, sorry. Make sure you shut the door behind you, okay? That's all right, thank you.
It's late. I'm not positive he's right or wrong, but it is late. We have had this now for going on however many days. I'm asked over and over again, is that it? It's late. I mean, we're in the middle of charging this jury right now, and we've said the words, and now we're gonna come back and say something totally different.
I do think it's waived. We had an on the record charge conference in which you agreed you had no objections to the charge. All of you back there may be seated. That's pretty clear. Anything else now that I've sent that away? I will, there it was. Okay, all right. I will return in a minute.
All rise. You're right.
So what that's it. They know how to play a match, so legislation knows how to They know how to propel.
Yeah, he both of them. What do I do? That's all. Yes, and that's why you don't need, that's why you don't. That's why that question, that's why this question was. It's not.
All rise.
Slant, the air conditioner pushes the bumper. May be seated. Right, so Mr. Reynal has raised an objection to the jury charge. That objection is overruled due to waiver. We've already had a conversation, a formal jury charge conference on the record in which no objections were raised, so that opportunity has passed. We will pick back up with instruction number 6, and I'm ready for the jury.
All rise.
You may be seated. Right, rather than reread everything I already read to you, I'm just going to go back about a paragraph and start back from there. Ms. Matishek-Steele, you've been running around like crazy, but if you have copies for the jury, well, at this point, I guess we'll just give them to you when you go back. I forgot to ask her. Okay, so we're going to go back to reading the charge. Number 6, answer yes or no to all questions unless you are told otherwise. A yes answer must be based on a preponderance of the evidence unless you are told otherwise. Whenever a question requires an answer other than yes or no, your answer must be based on a preponderance of the evidence unless you are told otherwise. The term preponderance of the evidence means the greater weight of credible evidence presented in this case. If you do not find that a preponderance of the evidence supports a yes answer, then answer no. A preponderance of the evidence is not measured by the number of witnesses or by the number of documents admitted in evidence. For a fact to be proved by a preponderance of the evidence, you must find that the fact is more likely true than not true. 7, do not decide who you think should win before you answer the questions, and then just answer the questions to match your decision. Answer each question carefully without considering who will win. Do not discuss or consider the effect your answers will have. 8, do not answer questions by drawing straws or by any method of chance. 9, do not trade your answers. For example, do not say, I will answer this question your way if you answer another question my way. 10, the answers to the questions must be based on the decision of all 12 jurors. 11, a fact may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when proved by documentary evidence or by witnesses who saw the act done or heard the words spoken. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from other facts proved. 12. You are the sole judges of the credibility or believability of each witness and the weight to be given to his or her testimony. In weighing the testimony of a witness, you should consider their relationship to the party, their interest if any, in the outcome of the case, their demeanor or manner of testifying, their opportunity to observe or acquire knowledge concerning the facts about which they have testified, their candor, fairness, and intelligence, and the extent to which they have been supported or contradicted by other credible evidence. You may, in short, accept or reject the testimony of any witness in whole or in part. As I have said before, if you do not follow these instructions, you will be guilty of juror misconduct, and I might have to order a new trial and start this process over again. This would waste your time and the party's money, and it would require the taxpayers of this county to pay for another trial. If a juror breaks any of these rules, tell that person to stop and report it to me immediately. Cause of action number 1, defamation committed against Neil Heslin. You are instructed that defendants Alex Jones and Free Speech Systems, LLC committed defamation against Neil Heslin. You are further instructed that defendants Alex Jones and Free Speech Systems, LLC published statements that were false and defamatory concerning Neil Heslin on June 26, 2017 and July 20th, 2017. Publish means intentionally or negligently to communicate the matter to a person other than Neil Heslin who is capable of understanding its meaning. False means that a statement is not literally true or not substantially true. A statement is not substantially true if, in the mind of the average person, the gist of the statement is more damaging to the person affected by it than a literally true statement would have been. Defamatory means an ordinary person would interpret the statement in a way that tends to injure a living person's reputation and thereby expose the person to public hatred, contempt, or ridicule, or financial injury, or to impeach the person's honesty, integrity, virtue, or reputation. You are further instructed that defendants Alex Jones and Free Speech Systems, LLC knew or should have known in the exercise of ordinary care that the statements published on June 26, 2017 and July 20th, 2017 were false and had the potential to be defamatory. Ordinary care concerning the truth of the statement and its potential to be defamatory means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. You are further instructed that at the time defendants Alex Jones and Free Speech Systems, LLC published the statements on June 26, 2017 and July 20th, 2017, defendants knew the statements were false as it related to Neil Heslin, or that defendants published the statements with a high degree of awareness that they were probably false, to an extent that defendants, in fact, had serious doubts as to the truth of the statements. Question number 1. What sum of money, if any, should be assessed against defendants and awarded to Neil Heslin as exemplary damages for the conduct related to defendants' defamatory publications on June 26, 2017 and July 20th, 2017? You are instructed that you must unanimously agree on the amount of any award of exemplary damages. Exemplary damages means any damages awarded as a penalty or by way of punishment, but not for compensatory purposes. Exemplary damages include punitive damages. Factors to consider in awarding exemplary damages, if any, are: 1, the nature of the wrong; 2, the character, the conduct involved; 3, the degree of culpability of the wrongdoer; 4, the situation and sensibilities of the parties concerned; 5, the extent to which such conduct offends a public sense of justice and propriety; 6, the net worth of defendants. Answer in dollars and cents, if any, and there's a line for the number. Cause of action number 2, intentional infliction of emotional distress committed against Neil Heslin and Scarlett Lewis. You are instructed that defendants Alex Jones and Free Speech Systems LLC committed intentional infliction of emotional distress against Neil Heslin and Scarlett Lewis in a continuing course of conduct from 2013 to 2018. Intentional infliction of emotional distress means the defendant acts intentionally or recklessly with extreme and outrageous conduct to cause the plaintiff emotional distress, and the emotional distress suffered by plaintiff was severe. Extreme and outrageous conduct means the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Question number 2. What sum of money, if any, should be assessed against defendants and awarded to Neil Heslin as exemplary damages for the conduct related to defendants' intentional infliction of emotional distress from 2013 to 2018? You are instructed that you must unanimously agree on the amount of any award of exemplary damages. Exemplary damages means any damages awarded as a penalty or by way of punishment, but not for compensatory purposes. Exemplary damages include punitive damages. Factors to consider in awarding exemplary damages, if any, are 1, the nature of the wrong, 2, the character of the conduct involved, 3, the degree of culpability of the wrongdoer, 4, the situation and sensibilities of the parties concerned, 5, the extent to which such conduct offends the public sense of justice and propriety, 6, the net worth of defendants. Answer in dollars and cents, if any, and there's a line for the answer. Question number 3. What sum of money, if any, should be assessed against defendants and awarded to Scarlett Lewis as exemplary damages for the conduct related to defendants' intentional infliction of emotional distress from 2013 to 2018? You are instructed that you must unanimously agree on the amount of any award of exemplary damages. Exemplary damages means any damages awarded as a penalty or by way of punishment, but not for compensatory purposes. Exemplary damages include punitive damages. Factors to consider in awarding exemplary damages, if any, are 1, the nature of the wrong, 2, the character of the conduct involved, 3, the degree of culpability of the wrongdoer, 4, the situation and sensibilities of the parties concerned, 5, the extent to which such conduct offends a public sense of justice and propriety, 6, the net worth of defendants. Answer in dollars and cents, if any. There's a line for the answer. Presiding juror, when you go into the jury room to answer the questions, remember that the presiding juror has these duties. 1, have the complete charge read aloud, be helpful to your deliberations. 2, preside over your deliberations, meaning manage the discussions and see that you follow these instructions. 3, give written questions or comments to the judicial executive assistant, who will give them to the judge. 4, write down the answers on which you agree. 5, get the signatures for a verdict certificate. And 6, notify the judicial executive assistant that you have reached a verdict. Instructions for signing the verdict certificate. Members of the jury, in discharging your responsibility on this jury, you will observe all the instructions that have been previously given you. And there's my signature. Verdict certificate. I certify that the jury was unanimous in answering the preceding questions. All 12 of us agreed to each of the answers. The presiding juror has signed the certificate for all 12 of us, and there is a signature and printed name line for the presiding juror. All right, at this time, we're ready for argument. Who will be doing the argument?
Oh, yeah.
All right. You may proceed whenever you are ready.
If you may please court.
Yes.
Members of the jury, my words today will in no way be able to express our gratitude for the first verdict. On behalf of Mrs. Lewis Mr. Heslin, Mr. Farah, Mr. Bankson, Mr. Ogden, thank you. Thank you. You have been heard. With your verdict, you have restored Jesse's name. You have restored Jesse's honor. And we are grateful for that. Incredibly grateful for that. You will now allow both of these fine people to begin the healing process that they should have been allowed to begin almost 10 years ago. And for that, they, I, us, could not be any happier. Your verdict is your voice. And your voice will reach wide and far outside the walls of this courtroom. With your voice in this trial, you have the ability to send a message for everyone in this country and perhaps this world to hear. We ask that you send a very, very simple message. And that is, stop Alex Jones, stop the monetization of misinformation and lies, please. Charge that was just read to you. I want to go to page 4 of it, and you'll have a copy. But I want to remind you that this is the second stage of the trial, but that doesn't mean that the evidence that was produced in the first stage of the trial is now gone. That evidence is still at your disposal and for you to use. And I think you will do in coming to an understanding of just how despicable the conduct was, which is a question you'll be asked and that I will go into. But before we talk about those damages, I want to remind you that on page 4 of the charge you have been given, it states, you are instructed that defendants Alex Jones and Free Speech Systems, LLC, committed defamation against Neil Heslin. On page 6 of your charge, it states, you are instructed that defendants Alex Jones and Free Speech Systems, LLC, committed intentional infliction of emotional distress against Neil Heslin and Scarlett Lewis in a continuing course of conduct from 2013 to 2018. I think we know that, and I want to remind you of it because what I want to talk to you about today is what and how that wrong is further righted and how a message is sent and how punishment is exacted. You have 2 jobs still remaining in this trial. First, you are asked to punish Alex Jones, the man who's not sitting here today and who can't face you. Secondly, you are asked to deter Alex Jones from ever doing this awfulness again to another family or another person, and to deter others who may want to step into his shoes. That's such a big thing to understand, and I know it has to be enormous in terms of looking at you or yourselves as the one who is given the task to do it. But I want to make very clear here that you have that opportunity, and that opportunity is one that may never come again. You have the ability today, truly you have the ability today to stop this man from ever doing this again, from continuing to tear the fabric of our society apart for the great monetary gain that he has received thus far, and to send a message again to those who desire to do the same. We've said it in this courtroom before, and I'll say it again. Speech is free. Lies you pay for. With your verdict, you hold such great power. Do. However, it's the power that you do not hold that I find to be the most compelling when it comes to rendering your final verdict. I say that because make absolutely no mistake, you do not have the power to teach Alex Jones a lesson. You do not have the power to change Alex Jones. And you do not have the power to make Alex Jones care. He will not be taught, he will not care, and he will not change. That has become so incredibly obvious to us on the inside of this courtroom, and for that matter, on the outside of this courtroom, what he has done. Throughout this trial, he hasn't been here except for the times, I guess maybe when he's not selling his supplements. But if you will recall, when Neil Heslin sat on that stand and shared with you some of the most intimate moments of his life, Alex Jones contemporaneously at that moment was on his radio show telling a national audience, a worldwide audience, that that man was slow and that he was on the spectrum. Saying that is vile, standing here right now, is honest to God probably the largest understatement that I could ever make with mere words. It demonstrates that Alex Jones does not care, that Alex Jones will not change, and that Alex Jones certainly has not and will not learn his lesson. So many times Jones has been given the opportunity to stop, to just literally to just stop saying what you're saying. So many times he's been given that opportunity to right a wrong. He says, "I'm sorry," and he immediately, after he says, "I'm sorry," says something awful, something defamatory. Alex Jones doesn't want it both ways. Alex Jones wants it all ways, every way. And if you allow him to have it that way, that's the way he will have it. He will talk out of both sides of his mouth the rest of his life, to the detriment of our society and other good families like that. One, two, three, four, maybe five. I count 5 cameras on the inside of this room. I'd like to think that those cameras are here on the inside of this courtroom because they are here to support Neil and Scarlett. I would like to think that those cameras are on the inside of this courtroom because they care in seeing a wrong righted. I would love to think that. It is not why they are here. They are here for this man his attorneys and his show. That is it. And it sickens me to know that that is the honest to God truth. Not only does it sicken me, it absolutely frightens the hell out of me. Because be certain, with the harshest of punishments that you could hand down to Alex Jones, he will find a corner on South Congress with a bullhorn and spew his hate and fear for everyone in the area to hear. And if you allow him to rebuild, he will take every one of these cameras and he'll rebuild. They'll follow him around. It baffles me that that's the way it will work, but it is. That will happen if you allow it to happen. I ask that with your verdict, you not only take Alex Jones' platform that he talks about away, I ask that you make certain he can't rebuild the platform. That's what matters. Take him out of this discourse, of this misinformation, of this peddling of lies, and make sure he can't do it again. That is punishment. That is deterrence. Misinformation spreads 6 times faster than the truth. That's what we heard on that stand, and I believe it. Alex Jones found a way to monetize that. Boy, did he find a way to monetize it. And in monetizing that, he made a wealth, a huge, huge amount of money. I hope that we never see someone like him again. I hope that with your verdict, he can go away. Alex Jones is patient zero for our society's inability to speak without lies. I believe it. He is patient zero for alternative facts. You heard it on that stand. Ms. Karpova on that stand literally used the words alternative facts or alternative reality, something like that. Sickening that literally should stand under oath and say that. But the problem with it is that's what he has been saying. And that's the reality that he wants this world to live in so that he, again, can have it always and make money off of it. I'm just playing devil's advocate. I'm just looking at the other side of it. Those are words that are said when you lay a base of misinformation, when you give a foundation of different realities. Now you can say there are alternate truths. One has to come before the other, and he's done it, and he needs to stop. The testimony that he lost his money after being kicked off of Twitter, Facebook, and all these other platforms. Lie. It's a damn lie. And we know it's a lie. We got an email from him, or excuse me, a text message that, thank goodness, his attorney accidentally gave it to us, or we wouldn't even have known this. But we got a text message that says he made almost $4 million in 1 week, years after he was kicked off of his platforms. You think he just randomly, accidentally stumbled backwards into $4 million in 1 week? And that's after he lost all this money from deplatforming? I tell you this because we know that everything the man said on the stand is virtually a lie. When he breathes, he lies. there's a portion in your charge that talks about the credibility of the witnesses. I want to read it for you. You are it's number 12, in case you want to look at it, page 3. You are the sole judges of the credibility or believability of each witness and the weight to be given to his or her testimony. In weighing the testimony of a witness, you should consider their relationship to the party, their interest, if any, in the outcome of the case, their demeanor or manner of testifying, their opportunity to observe and acquire knowledge concerning the facts about which they have testified, their candor, their fairness, their intelligence, and the extent to which they have been supported or contradicted by credible evidence. I stand here today and tell you that everything Alex Jones said on that stand that we didn't make him say was a lie. He lied to make his money, and he's lying to keep his money. $135 to $270 million. That's what Dr. Pettingill said on the stand based on the research and information and background that he has in forming an opinion about how much money Alex Jones and his media empire has. And believe me, it is a media empire. It absolutely is. He has got a hold on it, and it will do nothing but grow and grow and grow and grow if you don't cut it out. And that, by the way, is the money we know of, the 170 or 135 to 270. That's the money we know of. We don't know of the other money because we begged for the information on it, and he just wouldn't give it. And there's only so much that the court can do. Don't reward him for that. His defiance of truth, his defiance of the court, his defiance of you, don't reward him for that. Remember the operation Cover Your Ass that he talked about with Badandi, or Badandi talked about? The way that the reporters are supposed to make sure that they don't get sued for the vile hate that they spew. It's the same thing with this money. Cover your ass. And people who have the ability to make hundreds of millions of dollars get the opportunities of high-priced lawyers and accountants that no one even really knows about unless you have that much money, so that you can make sure no one knows that you have that much money. Rest assured that's exactly what has happened here. Thank goodness for the months and months of investigation that we were able to go into just to find the amount, the minimum amounts, the 135 to 270. And remember, when you're looking at when you're trying to determine the amount, it's based on a standard of the greater weight of the credible evidence, the tipping of the scales. How much does he have? How much does he not have? I say that because remember this. We are the only ones who brought you evidence as to Alex Jones and at least the net worth that we know of. That was unrebutted. So the greater weight of the evidence right now is very skewed. There is none on one side, and there is a lot on the other. Your $4.1 million verdict, we are incredibly grateful for, as I have told you. And I want to make this clear. It's going to change Scarlett and Neil's life forever. It will. It 100% will. Know that you've done that already. Feel good about that. They do. They feel wonderful about But what I also likewise find amazing about your verdict is that it doesn't affect Alex Jones' life one bit. 4.1, and we're looking at 270 million. I mean, we're talking less than 2% of what we know about. It affects him not, zero. It affects him so little that yesterday he was calling it the win of all wins in celebration.
Objection facts not necessary. The jury will start to disregard the last statement.
It's sustained, but that's always the instruction. You don't need to pile on.
I can assure you that a reasonable inference from the evidence we have in this case right now is that Alex Jones hopped and skipped his way out of this courtroom after he found out that the verdict thus far was less than 2% of what we know that he has. Because money is what that man cares about. He was a literal human infomercial on the stand. He can't stop it. I mean, I honestly, I don't think he even knows he's doing it. When he goes to dinner with his friends, does he literally, if he has friends, does he literally just start into how great his supplements are? That wasn't a question on the stand. It blows me away, and it gives me some insight into the man about what he cares about. And it's nothing other than selling supplements and making money. And he doesn't care that he stepped on this family. He has no care for that at all. He'll make $4.1 million back in a week or two, or maybe a month. Hell, he's probably already made it back in donations. He'll definitely make it back in donations sometime in the real near future. I say it only because, not that we're not grateful for it, but because your verdict doesn't punish and it doesn't deter thus far in any way. And that's what this stage is for. What will it take to punish and deter this man? That's the issue, right? We go back to the charge. On page, this is given a couple times throughout the charge, but factors to consider in awarding exemplary damages. These are factors to consider. They're not the only factors, but these are factors to consider. And it's the nature of the wrong. I think we can all agree that it is just horrendous to lie about someone's dead child and to drag this family through what they drug them through. The character of the conduct involved, find worst character of the conduct, and I'd like to hear about it because I haven't heard about it. The degree of culpability of the wrongdoer, he did it for money. He intentionally did it for money. I mean, you're instructed that to know that it has been found, he intentionally did it. The situation and sensibilities of the parties concerned, he's making fun within his own company of the person who was saying all these crazy things, Wolfgang Halbig first, calling him an absolute nutbag, sending someone to Newtown, knowing that person was an absolute nutbag. I mean, yeah, the situation and sensibilities of the parties concerned show you that there were no sensibilities, right? He knew it, but there wasn't. The extent to which such conduct offends a public sense of justice and propriety. A public sense. This is on behalf of everyone. For everyone in the public to think, or not everyone, but 24% to think that something was wrong or that Sandy Hook didn't happen. I mean, it blows my mind that that could even be a possibility in someone's mind. But it wasn't in Alex Jones. He knew what happened, but he was making money off of telling other people other things, the opposite of it. And the net worth of defendants, the net worth of Alex Jones. We started this trial asking you for $150 million. And we stand by that request. We ask that you give another $145,900,000. That plus your verdict is $150 million. That's what we believe is fair for the purposes of punishment and for the purposes of deterrence of not only Alex Jones, but deterrence in the public of doing this stuff again. Send a message to those who believe that they want to profit like he has and tell them, do it, and you will be in the same position. Stopping Alex Jones stops the root of his message, and the root of his message is fear and hate. Members of the jury, combating that message of fear and hate is something that Scarlett Lewis has devoted her life to. And you heard about it. It's absolutely beautiful what her movement does. She combats fear and hate through the Jesse Lewis Choose Love movement. It is a movement of love that has impacted so very many lives, and we desperately at this time in our society need for it to impact more lives and more lives and more lives. Love over fear is a choice. It is. Miss Lewis thankfully figured that out and sees the power in that choice. But making that choice of love over fear is difficult in our society today, right now, at present. Because at present, it seems like fear has the bullhorn. Fear has the voice. Fear has Alex Jones' airwaves. So I ask of you to take the bullhorn away from Alex Jones and take the first steps towards taking that bullhorn away from all the others who have it, or all the others who might want it, all the others who believe they can profit off of fear and misinformation. Make them understand that they too will sit their ass in that chair right there and have to actually respond in a court of law for what they do if they choose to do the same thing that Alex Jones did. With your verdict, you can create so much of a better opportunity for love and truth to be chosen over fear and hate. I'm again asking you that you return a verdict against Alex Jones and his empire in amount of $145,900,000. Jesse was a hero. I tell you what, I think I know where Jesse got his heroism from. I am asking you to tap into your courage today. Make a statement, loud and clear, that the gold rush of misinformation and fear must end, and it must end today. Thank you.
Thank you.
I have a moment to set up the computer.
All right.
Well, I guess we're gonna do it the old fashioned way. It's my honor and my privilege to address you for the last time in what has been a long case, a case with a lot of emotions for everyone concerned. And Mr. Ball brought a lot of emotion to his closing argument. I'm going to ask you once more to look at the facts and to look at the law. And I'm also going to ask you to think about what justice really means. I began my career as a federal prosecutor. Above my desk, I had a quote, still have it. It's from a book called Shantaram. And it says, justice is not just how we seek to punish those who have offended us. It is also how we try to save them. That is the balance that we seek to strike. Plaintiffs suggest that you should send a message. You've already sent a message. You've sent a message for the first time to a talk show host, and to all talk show hosts, that their standard of care has to be different. $4 million is a lot of money. And we'll discuss in a little bit how that money plays out in terms of the amount of time that Alex Jones actually spent on the air talking about Sandy Hook. I think if you do the math, which I had done, you'll find that it works out to about $14,000 per hour. That's about what FSS and Alex Jones make on the air. And as you all already know, what we have in evidence is, I think it was 18 hours, 40 minutes. $18 hours and 43 minutes. Keep that number in mind for what it's worth. I'd also ask you, who else needs a message? I talked a little bit about this idea that Alex mentioned from the stand of what it meant to grab two sets of people and treat them like pit bull dogs and throw them into a pit with each other. And I agree with Mr. Ball. These cameras are here for a reason. That's what they want to watch. They want to watch us tear each other apart on national television. And they want one side to die. That's what people want to see. And you were under tremendous pressure yesterday to make that happen. And you stood up to that pressure and you rendered a verdict based on reason and sense, which is what you should do again. First of all, this case is not captioned "The people of the United States of America versus Alex Jones." It's captioned "Neil Heslin and Scarlett Lewis versus Alex Jones and free speech systems." The verdict you render on exemplary damages is for Mr. Heslin and Ms. Lewis. And that's where the money will go, over here. It's not for the people of Sandy Hook. And it's not for the United States. It's for Neil Heslin, Scarlett Lewis, and the people who made sure that all 12 of you must agree. I'm sure yesterday was difficult. I've been part of this process going on 20 years. And my God, do I know how hard it is. You have to be true to yourself, each one of you, in making this decision. You speak with one voice, but you are individuals. Never give up, never surrender your own firmly held beliefs. I want to talk about the factors that the law says instructs you to consider. They're going to be in your jury charge waiting for you when you get back there. The first factor, there's 5 of them, that's our roadmap that we're going to go through. The first factor is the nature of the wrong. We've all, as I said, now devoted more time to talking about Sandy Hook in this courtroom than Alex Jones ever did in the evidence on the air. Alex Jones is a talk show host whose byline is tomorrow's news today. I mean, just think about that for a second. Tomorrow's news today. He ran with a story irresponsible. He shouldn't have done it. He explained to you why it happened. And he said, I shouldn't have done it. It was crazy. I was wrong. And we have changed things. Every InfoWars employee who came talked about that. Now, despite having made a mistake, he was reporting on a topic of national importance. And we should keep that in mind. It is a sad truth that whenever a tragedy like Sandy Hook happens, the first people who are talking about CYA, cover your ass, are the government officials who dropped the bag, who dropped the ball every single time. That is an important topic. That is a topic that needs to be spoken of. And you should take into account what effect your verdict here will have on other people who want to report on that topic. Because it will. It will. Everybody's going to look at this case. You've already said with your verdict yesterday, if you hurt somebody, you're going to pay for it, and you're going to pay for it handsomely because you need to make them whole. Let's look at the character of the conduct. 18 hours and 43 minutes, over 6 years.
Objection not. Inferring that that's the only video again.
Sustained.
Let's look at the evidence that they brought you. These fine lawyers over here, they brought you 18 hours and
That's not
43
the only
minutes.
evidence that we brought.
Sustained.
And there's more evidence that we could have brought.
Object to the side.
Sustained.
They chose what evidence they wanted to have.
That objection, Your Honor.
Approach. Don't let it get.
You have in the witness room to watch 18 hours and 43 minutes. That is 0.16% of Alex Jones's air. You have testimony from the plaintiffs themselves that they did not hear any of Alex Jones's broadcasts until 2018. You have in evidence that Alex Jones never said Scarlett Lewis's name. You have in evidence that Alex Jones mentioned Neil Heslin's name for the first time in 2017 after Mr. Heslin went on the medical. You have in evidence that Alex Jones never issued a call to action to anyone to do anything to Mr. Heslin and Ms. Lewis. Let's talk about the degree of culpability of the wrongdoer. Alex Jones was absolutely reckless in his coverage. He shouldn't have trusted Halbig. He shouldn't have trusted the check. It was wrong, and he admits. Now, when you look at the degree of culpability of Alex Jones, keep in mind the national conversation. Keep in mind the truthers who were online and who had been online. Remember Detective Jewis's testimony regarding the websites. I think we also have Rebecca Lewis regarding the hundreds of videos, websites about this that she saw and she read. Think about the Clinton campaign and how they weaponized the suffering of the Sandy Hook families.
Not evidence.
Sustained.
You have in evidence that during the 2016 election, there were nationwide ads taken out linking Donald Trump, Alex Jones, and Sandy Hook. Think about Megyn Kelly. Again, thrusting everything into the public eye. And think about the mainstream media who descended upon Sandy Hook in the wake of this tragedy. Misreported things. The situation and sensibility of the parties. Everyone in this room feels sympathy for Mr. Heslin and Ms. Lewis. You would have to not be human not to feel sympathy for them. But consider everything that we've accomplished during this trial. The exchange that we observed between Ms. Lewis and Alex while she testified. That was real. You all watched it That's the good that has come from this case. And it can produce more good in the future. The plaintiffs have a big voice. And that voice was yours yesterday. That voice has been repeated. They've been heard, and that's important. Let's talk about why Mr. Heslin and Ms. Lewis are so upset. They are upset because someone convinced them that 1 out of 4 Americans wants to hurt them. Did Alex Jones do that? It's crazy. Did Alex Jones do that? No. The extent to which the conduct offends a public sense of justice and propriety. We've already talked about this in the other factors. He ran with a story he shouldn't have about an issue of national insurance. The plaintiffs didn't hear about it till years later. At our trial, he has apologized, and he apologized on that stand repeatedly and offered to have the parents on the show. Let's talk about net worth. Many of the things that Mr. Pettingill said made absolutely no sense. One of them is that somehow you can take both FSS and Alex Jones and somehow together they're worth $270 million. We've heard so many times here, Alex Jones is FSS. Right? There's no FSS without Alex Jones. At most, you could infer that the future value of Alex Jones's services may be that amount. But I don't think that's supported by the evidence either. We didn't get any evidence as to what Alex Jones actually has today. We didn't get any evidence of what FSS has today, what money they have, what assets they have to pay a judgment. We got none of that. I know I've already gone on too long. You guys were probably ready to make this decision yesterday. But there's a couple more things that I want to touch on before I leave. A couple of thinkers. Louis Brandeis, the Justice of the Supreme Court, after the First World War, having seen how our government had imprisoned people for being anti-war activists, talked about having freedom for the thought that we hate. Why did he say that? What was the concept? The concept is that it is repression that breeds hate. When you tell people they can't talk, they can't freely.
Objection. This argument goes directly to the court's previous ruling on liability. Speech is not protected.
Sustained.
You did something extraordinary yesterday. You returned a verdict based on facts and reason, despite tremendous pressure. You've already sent a message to Alex. You get to speak. You have freedom of speech in this court. You are the most important people in this court. The most important. You are the deciders, and you do get to talk. No matter what anybody says, you get to talk. And when you talk, send a message. Send a message to the people who have cultivated the tremendous antagonism that we have in this court. Send them a message by return. I suggest to you that the way to do that is by taking the gross sum made, $14,000 an hour, and multiplying it by the amount of hours on those videotapes that you have. It's about $270,000. Return a verdict that is proportionate, that respects the effect that your judgment will have, and say to the people that have bred this tremendous antagonism, you will not be rewarded. It's been an honor to present this case.
Thank you, Mr. Reno. Is it relatively short, or do we need a break?
Break that, I mean, I don't know, it's probably gonna be 10, 15.
Okay, it probably won't be long, but we'll take a brief break so everyone will be comfortable. Let's keep it to 15 minutes, all right? Remember, all lines are closed. Thank
All
you.
right.
Okay.
Whichever one.
too.
I'll give him one. Yeah, let's figure it out. It's 1:30. Is that 1:30?
No.
Yeah, yeah, I got one more second. You got it. No, we got one. We don't use them anymore. Yeah, we got plenty. Basically, I would memorize it. So I know the correct version of proof. And I'll go project it. Sure. No.
That's one of those life's mysteries.
That's what I just said.
Yeah, so so they don't.
She says that to make it. Yeah. Because it wasn't on the record for that bench.
All rise. You may be seated. Paul, when you're ready.
Thank you, Your Honor. I want to take you back to something I said the first time we talked today. That is, I believe that Alex Jones will not change, that Alex Jones will not be taught a lesson. Alex Jones does not care. What I just heard this man say and everything that came out of his mouth, I am now further convinced that is exactly what we are dealing with. He says we have changed. Think about it. We saw on that stand an evidence that came in while during this trial of a judge on fire, allegations that a jury was being manipulated, allegations that the jury didn't know what they were doing. We've heard that there's some great conspiracy theory that Neil and Scarlett are being used by the dark forces. I mean, seriously, think about it. Like, we're in it right now. We are in this reality that he tries to come up with. It blows my mind that we sit and argue about this conspiracy theory that Alex Jones came up with, that their son didn't die. And then he comes in here and says, it happened. It absolutely happened. But it happened, and we're now currently inside another conspiracy theory. I mean, the irony there, the hypocrisy is so thick I can cut it with a knife, a butter knife. They haven't changed. They won't change. That man will sit here and spew his lies and misinformation as long as he keeps getting a check. Because that's what Alex Jones does. He cares about his money, he cares about getting his money, and he pays people to ensure that he can continue that in perpetuity. The thought, the defense that I've heard over and over again, that's been objected to over and over again, of the 18 hours of video, the 0.16%. "18 hours is probably 1/100th of the amount of video that exists of Sandy Hook. You understand that? I mean, they destroyed the remaining video. They didn't produce the remaining video. And then they stand up here and tell you, it's kicked the door wide open to all this.
I wasn't allowed to discuss these things.
Well, what is your,
Positive testimony in this case, that's not all of it. to hide behind the thought that those are the only videos that exist of Sandy Hook, to then come in here and use that thought that is not true. We heard it in this case. Paz said that's not the only videos that exist. We know that's not the only videos that exist. I don't know how many more hundreds of hours, tens of hours, thousands of hours of videos exist. I don't know. I can tell you we did everything in the world to find out, but I don't know that. He definitely doesn't know it. And to stand up here and say that 0.16% is all that they did, or imply that that's all that they did, and then ask you to base a judgment off of that, that right there is literally what alternative facts are. I mean, if they're going to stop doing it, then stop doing it on the inside of this courtroom at a very minimum as a first step. I mean, they said they had no text messages. No text messages. And they also are saying they have no money. Right? Think about it. We got no text messages about Sandy Hook. We got no money. Please, if you would, bring up PX 130. If you would, go to the portion that I'd like for you to blow up. Get the very top right here. With the I get it. A text message from 2020. Alex Jones text message. Remember, he authenticated it. He said it was his on that stand for the very first time. Also the very first time that Alex Jones knew we had this text message. I think it was the first time that anyone for Alex Jones realized we had this text message. But it says, this is a video of a medical student training to intubate. Makes us look ridiculous, suggesting this means COVID is fake. Sandy Hook all over again. And then further in these text messages, we have text messages about the amount of money that he's making that week. So we have text messages about money, text messages about Sandy Hook. And they said, we don't have text messages and we don't have money. Well, we've got a text message about money. Think about it. But what is even crazier to me about this? Bring it up again, please, please. I mean, the text message says the video of a medical student training to intubate makes us look ridiculous, suggesting this means COVID is fake. Sandy Hook all over again. What I care about in this is the person that responded to it. That was Alex Jones. And what did he say? I get it. I.e., yeah, I understand. This absolutely is Sandy Hook all over again. This absolutely is stupid and ridiculous. But I think you heard the article is on InfoWars live right now. A year and a half ago, or I guess a little more than 2 years ago, the man is literally telling everyone that COVID is fake and he knows he's lying. He's not going to stop. They won't stop unless you stop. I heard him say what Alex Jones said was reckless. I mean, we know that already from what the court has given, what the court has charged you with. We know that they are reckless, that Alex Jones and what he said was reckless. We know that it was intentional. All right, but think about this Alex Jones representative saying I know he was reckless. Alex knows he was reckless. And then immediately going, but Megan Kelly said, but the truthers said, but there were other websites, but Hillary Clinton. Hell, at one point, I thought he was going to start yelling or chanting, lock her up. I mean, when's it going to be over with from that side? What they've attempted to do inside this courtroom with the facts presented to them versus what they say in response is a mockery. If they're willing to do it here under oath, they're definitely not stopping it outside when he's in his studio with his microphone in front of him. We brought you the only evidence of net worth in this case. They brought you absolutely nothing. If Alex Jones had got on that stand and said otherwise, he'd have perjured himself. And we know that based on the evidence.
Same.
If someone on that stand said something different from the evidence that we brought you, that would not have been very good for them. The evidence that we have in this case is that at a minimum, Alex Jones is an incredibly wealthy man. And he has made it based on peddling lies and fears. I hate so much that our society today wants, for some unknown reason, to hear lies and fears, a segment of our society. It tears me apart. I do everything I can just with my daughters to talk to them about it, to try to shield them from it one way or the other. I can't figure it out. I can't. I swear to you, I can't. I don't know why. I don't know why so many people like the man. I don't. If I could figure that out, we could do more good than what we're doing right now, but I can't figure it out. But it exists. It's a thing. I would like to start making it not a thing. And that is you. You have that ability. You have the ability to tell everyone, stop. Please, please stop. Choose love over the fear and hate that the man peddles. He stood up here and he said, you know where the money's going to go? Well, you know what's in Scarlett's heart. You know what's close to her. You know what drives her and what her passion is. I don't have to link to you where he's going to go. If he's going to sit here and say it's just going to go straight to her, it's just going to go straight to him. You're smart. You understand. Cannot again impress upon you the importance of the job that you have been given and the number of people. Even though I'm not necessarily positive that these crews in here are here to hear that message, the people who are watching through that camera, some of them are here to hear it and they want to hear it. Please, please let them hear it. The man is worth almost $270 million that we know of. Take an amount from him that punishes him, and then taking another amount that ensures that he never does this again. Thank you.
Thank you, Mr. Bell. In a moment, you will retire to the jury room. You will be given the charge and begin your deliberations. We'll bring you the charge. As you're back there, the exhibits are already waiting for you. When you are all together, you may deliberate on this case. My other instructions remain in place. Thank you, and you may head back.
All rise.
So just shut the door, please. Thank you. You may be seated. All right, I don't think I need to go over all the instructions for what we do while they're deliberating. It's the same as it was before. And so we'll go off the record and we'll take that time now.
Thank you, Judge.
Thank you.
At some point, I have a couple of matters for you, but I don't know if you want to do it.
All right, let's all have a lunch break
I
and then
agree.
we'll come back out. We know how to get.
All rise.
Thank you.
Thank you.
I do, yeah, you can come back from your house.
Won't sanction me again. That's gonna be what they want to bring up. You wanna go have lunch? Yeah, what's, I think we'll probably go back to where we had breakfast. Works for me.
Our camera, somebody adjusted it during the break. Somebody did it. Because it's now facing the ceiling. So you want the camera. Someone removed the camera. And I have someone who called me and said that the sheriff deputy did it. No, none of you guys? All right, the judge wants to know who was it. Because it used to be, you can't even see the fence anymore, and it happened while the jury went on bail back. And you asked for questions, and then they came back in, and now it's facing the jury. So if you find out. Oh, I'm sorry. follow the judge's instructions. You don't have that capability. Somebody asked me first if I asked. It could have been, yes. Oh. I don't know what it is. Sure. Thank you. We use lots of paper.
Yeah, well, that's a fact.
Sorry.
A fact.
All rise.
You may be seated. Speaking through your presiding juror, members of the jury, have you reached a verdict? All right, Ms. Nicolette, could you hand the verdict to Ms. Steele, please? Thank you. Thank you. Obviously, this verdict is unanimous, as that's what's required. I will read the answers. Just gonna make sure everything's filled out properly first. Question number 1, $4,200,000. Question number 2, $20,500,000. Question number 3, $20,500,000. All right. This question is addressed to my jury. Is this your verdict? So say each and all of you. Thank you very much. Would the attorneys like to examine the verdict?
No.
All right, then I'm going to accept this as a verdict of the jury and order that the clerk enter it upon the minutes of the court. All right, at this time, I am required by the rules of the Supreme Court of Texas to give you one more of the many, many instructions I have given you over the past 2 weeks. I have previously instructed you that you should observe strict secrecy during the trial and during your deliberations, and that you should not discuss the case with anyone except other jurors during your deliberations. I am now about to discharge you. After your discharge, you are released from your secrecy, and you will then be free to discuss the case and your deliberations with anyone. However, you are also free to decline to discuss the case and your deliberations if you wish. After you are discharged, it is lawful for the attorneys or other persons to question you to determine whether any of the standards for jury conduct that I have given you in the course of this trial were violated, and to ask you to give an affidavit to that effect. You are free to discuss or not discuss these matters and to give or not give an affidavit. Ladies and gentlemen, I want to thank you again for your jury service. Without it, our system of justice could not exist. I hope that you have benefited to some extent by your being a crucial part of this trial. I will release you, and then Ms. Steele has some paperwork for you, and then I will step into the jury room in a few minutes to thank you a little less formally, excuse me, but you are now excused. Thank you so much.
All rise.
You may be seated. I think for the record, I'm going to ask the plaintiff's side to prepare final judgment on my signature.
Absolutely.
I think that might be all we need on the record. Is there anything else?
I have something I want to put on the record that's post trial proceeding. Like, I need something on the record today, just so it's contemporaneous.
Okay,
But I don't know if it needs to be at this moment. If you have other things to do.
okay,
Simply, Your Honor, that we ask that the plaintiffs make an election as to Mr. Heslin, and also to notify the court that the verdict does not conform to Chapter 41 of the Texas Civil Practice and Remedies Code, and that we will be filing an objection to the entry of judgment.
yes, so we do have laws in Texas where we claim to trust our juries and then we don't trust our juries. That's true. And I'm sure the judgment will properly reflect the laws of the state of Texas in that regard. So don't need to worry about that. I think now is a fine time to put something on the record if it needs to be done today.
Sure. Okay, Your Honor.
And you can sit down. Sorry, I thought I had said that.
Let me
Okay, Your Honor, I have two things that I want to cover really quickly. I hope they're quickly anyway. As we had spoke about earlier in the trial, we definitely are preparing a post-trial motion for sanctions. My concern and why I just want to put something on the record, this isn't for you now, I know you can't rule on it now. I've come across quite a bit of law that says if I don't raise my objection to what's going on in a couple weeks when I file my motion, I may have waived my ability to have sanctions. So I want to do that just in a brief summary fashion now so I can have those points out. Obviously, having already secured millions of dollars from Mr. Jones before the jury went back for punitive damages, certainly didn't want to mistrial. But some things came up that I believe are sanctionable. Dealing with us parties for the past, since 2021, we were remanded. I know you've seen a cavalcade of lawyers come in and out and sanctionable conduct, and it doesn't stop. The three things I want to bring up first is that Mr. Reynolds constant relying on the expression to the jury of that there were 27 hours of video of Sandy Hook coverage. I want you to think back to the first objection in this case. You've heard so many objections in this case, but the very first one was Mr. Reynolds' board that was over here with the 27 hours. There have been at least, since that was ruled to be not an appropriate statement to make to the jury, there have been, by my count, at least 10 times where that has occurred, and objections have been raised on that. And in fact, your words to Mr. Reynolds were crystal clear. Mr. Reynolds, you cannot do that. Mr. Reynolds didn't care. He got up in the closing statement and did it again. But this time it was even worse. He didn't just say that 27 hours were the total, which is bad enough, because he had said, we've devoted more time to Sandy Hook than Alex Jones ever did. When Mr. Reynolds made that statement, he knew it was false. He knew that was a false statement. But it's worse because he started to say that we either could have or should have brought evidence of the additional videos and claimed that it was our fault for not putting more videos in front of the jury. And in this particular case, we believe it is outrageous for a defendant and his attorney and an entire attorney team to hide, destroy, and tamper with evidence, which this court's already found, and then tell our jury that it's our fault for not having it. We think beyond just the expression of what he knows is false about the 27 hours, he used the fact that we were behind the 8 ball, that people have testified repeatedly in this case that videos have been destroyed and God knows where they are. And that we requested videos, I think you'll remember, and transcripts that we never got, that we inadvertently got later that there were some transcripts prepared by a court reporter of those videos in 2019. And we still don't have them, which means they were in counsel's possession because they were sent to a court reporter for transcription. We believe that is so outrageous that we will be seeking sanctions of the highest caliber for all of that. The second is that this court has, in this entire district, has a standing order in limine regarding the social costs of the jury. And what this is you cannot tell a jury that punishing a guilty party will have an effect on non-parties who are not engaged in unlawful conduct. The most classic example of this would be in a car wreck case to say it's going to raise all your insurance rates. You can't say that. In this case, there was substantial argument about the substantive effect this would have on non-parties who are engaged in protecting non-illegal speech, and that would suppress their non-illegal speech, and therefore you can't punish this person because it would have the effect of deterring legal speech. That is absolutely impermissible. That is a social cost of an award. That violates motion in limine 21 in the county standing order. Finally, there is a motion in limine that is granted by this court that prevents the defendants from contesting allegations in the plaintiff's petition. One of those key allegations is that Alex Jones is Free Speech Systems, and that Alex Jones is an alter ego of his own company. That was an accepted allegation that was admitted by the default judgment, and in fact, that order in limine was an agreed order from the defendant's side. During the closing argument, we were lambasted for lumping these two together, and there was plenty of argument about how they may be separate. So we have 3 different grounds that we need to raise at this time for a contemporary objection that will be added to basically every single day. We're going to have something we're going to bring in that motion for sanctions. So we needed to bring that to you now. The second thing I wanted to talk to you about, and maybe you want to talk about it separately, or I don't know what we can do about it, but I have not been given any confidential designations about that phone. I'm ready to hand
I
it
think
over
you're,
right now.
I thought you already had.
Yeah, I'm prepared right now to hand it over to whoever wants it, because nothing about it's confidential. And I did get
Just don't
some.
knowingly transfer other people's private medical information.
Exactly. And I believe there might be some other private, I mean, whatever I do will be consistent with my duties as a professional responsibility. But there was a privilege log filed this morning. It is not compliant for many reasons. One, it's just not a compliant privilege log. Doesn't identify any documents, doesn't provide dates, doesn't provide a description of the subject matter, none of that. It's just every single communication I have with this person's privilege. A Texas privilege law has to identify each specific document sufficient for me to be able to identify the privilege. But it doesn't really matter because privileges are. We're 14 days past inadvertent disclosure notice. We had that time running, so we believe that privilege log is ineffective and meaningless. But because it has been filed and there has been an assertion of privilege, I would like to get a ruling for the court instead of just my assumption that privilege does not apply.
Well, I thought my order yesterday was that that Mr. Reynal had yesterday to identify any specific documents.
In terms of confidentiality, yes.
In terms of confidentiality.
In terms of
that's right.
privilege, I think we reached that this way. But in terms of confidentiality about releasing it outside of this lawsuit, it was provide those to me today. We don't have any, it basically
Well,
just said we can't.
Yesterday.
Right, correct.
Yes.
Correct, Your Honor. So those are the two things I wanted to raise today.
All right, Mr. Reynal.
I don't think that Mr. Bankston's first speech deserves a response at this point because there's nothing before it. As to the issue of the privilege log, we sent a letter to Mr. Bankston this morning. We copied the court on it. There are core attorney-client privilege communications in there. We identified them by document. It's a PDF. We said, these are his communications with his lawyers. I think that satisfies the rule. I also believe that the time has not passed because we became aware of the inadvertent disclosure while Mr. Jones was testifying.
That's not true.
Well, that is our position, Your Honor.
Oh, okay, you're the one who gave me the email that showed me that you had known about it 12 days earlier.
Mr.
So
Bankston represented in that email that he was not going to download the documents.
that is
Therefore,
not true.
that is our position, Your Honor. I mean, you have the email, so
But
it's,
that's right. I have it and I read it and I saw what it said and it didn't say what you just tried to tell me.
well, if Your Honor disagrees, that's her prerogative.
I disagree with the written word in front of me. Yes, that's right. Thank you. I will review the motions for sanctions when you file them, and we'll set a hearing for them then. I don't think I have anything to do with regard to the phone that I have not already done. I frankly thought you had already responded to any requests you may have received from Congress. I'm not standing between you and Congress. That is not my job. I'm not going to do that. All right.
There's the phone, it's not even a phone. The text
I don't-
messages from 2019, they have
Okay.
nothing to do with Congress.
I'm not getting in the middle of that. Nothing is properly before me to get in the middle of that fight. When and if it is, I'll make a decision, but it isn't right now. Anything else on the record with regard to this trial that we have just concluded?
Nothing from the plaintiffs, and thank you very much, and for the court staff service as well.
Thank you.
Nothing to do with that.
All right, we can go off the record. I've already told you that you have to prepare the judgment, and I would like that preferably by next week if possible.
We can get that.
I do go and speak with the jury, and it is my practice to invite attorneys to come and speak with them if you would like to. Given the hour, 5 o'clock, there's not going to be a lot of time, but if you're interested in that, I will send someone out to come and get you. Attorneys only, not parties. That's how I do it in every case. Now, when the jury leaves, of course, that's, I'm not in charge at that point. And we have made space available for both teams this week. I would like to, if you have not already, ask you to go and make sure that both spaces are clean and put away. You haven't left anything behind. And when those judges reclaim their spaces, they will be happy to have lent them to you. So if you'll take care of that right now as well, please.
Will do. Thank you.
All right, thank
No,
you.
I have
Oh,
one
one
other-
more thing.
Sorry, me too.
We're set for pretrial. September, okay, 19 is a Monday, so, Sunday, Saturday, so 18, 17, 16, the 14th of September in Posner. Posner.
At this point, the bankruptcy automatic stay applies.
I have not received any documents, so until I do, we're set on the 14th for an in-person pretrial in Posner. All right?
One other small question I had that I just remembered, in prior cases here in the county, I have typically let the jurors have a couple weeks off and then the judge has pulled them to see who would be okay with us contacting them directly 2 weeks from now, something like that. I didn't know if that was something you did or if you would ask the jury if it was okay if we could contact. I don't know.
So I think that's a conversation we should have in a different forum.
Okay.
But you've heard all the things I've told them about what's allowed and what's not allowed, and so I don't impose anything extra, if that
Excellent.
makes
Okay.
sense.
That does, Your Honor. Thank you.
All right, so I will see some of you in a little bit and the rest of you.
Thank you, Your Honor.
Thank you all very much. Has been challenging. It's been an exhausting 2 weeks, I think, for all of us, but I will say, for the most part, I have been very impressed and I'm pleased that we were able to get to a verdict. I think that was really important in this case. So thank you all.
All rise.